provided under section 125(4) of Criminal Procedure Code, it could be seen that the petitioner number 1, who is living separately from respondent, is not eligible for culminating maintenance from him. Maintenance is my statutory right. He has to provide me that maintenance. Not
before the family court. Not even one record has been produced that there is a land and there is an income from that. And she is running the beauty parlor. It's not closed. Sometimes this 125 also says that no wife who is entitled to maintenance if she deserts by herself.
Prepare for the petitioner, my lord.
Yes.
Petition filed by the petitioner for the maintenance was dismissed, my lord.
Yes. Let's see the order why it is dismissed.
Lord, yes, Lord. That translated copy I filed separately, my lord. May I read from the reasons, my lord? Last time also.
Yes.
My lord.
Yes, yes.
Yes. Reasons, my lord. Point number 1. According to the details in the petition, since the respondent completely neglected the petitioner, for which petitioner number 1 started beauty parlor by borrowing loans, even after that, the respondent who used to drink, come near beauty parlor and behaved immannerly, for which most of the customers stopped visiting the beauty parlor. Suffering from financial clock, she started relying on her deceased mother. While this being so, during COVID pandemic, she left respondent and returned to her own native and started residing there itself, wherein the respondent completely neglected to take care of the petitioner. The respondent denied all these points and stated that since he became deaf and was incapable of continuing his driving profession, and hence he set up a beauty parlor to the petitioner number 1, and petitioner number 1, who started having income from the said profession, used to have inferior attitude against petitioner who is deaf and completely neglected him, and then she expelled him out of the house since had no income, and at present he is living under the shelter of his mother. Both the parties produced several evidences before the court in order to substantiate their arguments and objections. Among them, only few reliable evidences are taken for examination. It is undisputed fact about the relationship between the parties, and that the petitioner is residing separately from respondent. Exhibit P1 to P5. Exhibit R. Invitation, birth certificate, etc. Notice are all also undisputed and are supplemental to this case. Though it is the stance of petitioner that the respondent himself abandoned the house and have neglected her, the supplementary evidence to prove the stance of PW1 are not available before the court. Also, any factors admissible for the allegations are not brought out in the cross-examination of RW1. In Exhibit P14, diverse notice issued by petitioner number 1 to the respondent on 28/12/2018, it is alleged that the respondent has caused physical and mental torture and abandoned her. But the document marked as Exhibit P15 as regards to the discussion permitted to petitioner number 1 by Mysore Women Police Station on 9/12/2018 and excluding the medical certificate marked as Exhibit P18 issued by the medical officers of Primary Health Care Center on 22/12/2018, and that she took treatment at Primary Health Care Center at Hale Agrahara on 10/1/2018, that her husband had assaulted on her about 3 days ago. There are no other documentary evidences before the court to conclude that the respondent has caused harassment on petitioner number 1. During the period of 16 years of marital life between petitioner number 1 and respondent. Moreover, PW1 herself during the cross-examination has adduced that she is not ready to live with the respondent. When all these factors are carefully examined, it could be concluded that there are no enough reasons to show that the petitioner number 1 is not capable of living together with the respondent. Hence, as provided under section 125(4) of Criminal Procedure Code, it could be seen that the petitioner number 1 who is living separately from respondent is not eligible for culminating maintenance from him. Moreover, the important point to be noticed here is that the petitioner number 1 has filed MC number 214/2022 before the first court against respondent seeking divorce. The said case was transferred to this court and the same was simultaneously inquired along with this court, and the said divorce case was ordered, under which petitioner number 1 got divorce from respondent. Despite there are no documents in this court, the said fact may be considered by the knowledge of this court. Hence, as explained in section 125 of Criminal Procedure Code, the petitioner number 1 does not come under the purview of wife, but she comes under divorced wife. And hence, though the divorced wife being petitioner number 1 has no source of income and the respondent is well stable in terms of income, if she proves that he has denied to take care of her and has neglected her, and then she would be eligible for maintenance from respondent till her remarriage or lifetime. When there is no question that petitioner number 1 is ready to live with her divorced husband, and since there is no need of adducing enough reasons to live. Milord?
I have seen. The court has directed the husband to take care of this educational expenses of the daughter.
Yes.
So the wife.
Daughter, no son. His son. He is studying in.
As far as the wife is concerned, it is rejected.
Yes, wife on maintenance both rejected. Only educational expenses for the son. He is studying in law now.
Yes. Yes. What do you
Lord,
say?
Here, he claims that I have the beauty parlor that has been closed because of his behavior only. He made me to close down that beauty parlor. I do not have any income and his income, my lord, he has got 3.5 acres of land, agricultural land. Not only that, he has a commercial building that he is taking rent, and also he has got cattle farming and all, my lord. And my lord, your lordship may kindly see, even he is a politician. For that, your lordship may kindly see that documents I have furnished before the court at exhibit. He is a active politician in a particular that is at my lord, exhibit P16 and P17.
Yes.
And he has sufficient income, and I have also many diseases. My health condition is also not permitting. And moreover, my lord, in this case, if at all, I have the income also, little bit income also from the source, maybe, my lord, and I have furnished a compilation of citations separately before your lordship, my lord. Your lordship may kindly see that compilation.
Yes.
That is separately I furnish it before your lordship, my lord. Citations, compilation of citations.
She is entitled for maintenance.
My lord?
As per the judgments, in spite of her income,
Yes, she is entitled for maintenance. Even though she has got little bit income, she is entitled for maintenance. Maintenance is my statutory right. He has to provide me that maintenance. Not only for me, now for my son also, because now he is a student. He has to be maintained. Now, whatever the trial court ordered is only and only for the educational purpose. That also he is not providing.
We are paying it, ma'am.
Yes. What do you?
Yes, they are stating that there is a land for him. there's a commercial building, not even iota of evidence has been produced before the family court. Not even one record has been produced that there is a land and there is an income from that. And she is running the beauty parlor. It's not closed. We can file an affidavit also to that effect. Mysore in main road itself, she's getting an income of monthly 60,000. This is
Not at
willful
all, my lord, not
desertion.
at all. It is absolutely false submission, my lord.
Just submit, you can reply to that.
This is willful desertion, my lord. The Honorable Family Court judge itself has noted in the judgment that she is not going to ready to live with him. So if she doesn't want me, but she
No,
wants
what
money.
125 says that divorce wife again should
Yes,
go
yes,
to
my lord.
husband and then they will be given
Yes,
maintenance.
my lord. At the same time, this 125 also says that no wife who is entitled to maintenance if she deserts by herself, deserts the husband by herself and lives separately. So this is one aspect, my lord. And second thing is,
The divorced wife,
yes, my
the
lord.
granting maintenance to a divorced wife, where is the question of willful desertion there?
Yes. After that only she went and filed divorce after decision. Then, my lord, kindly see para 16, and he is a deaf person. Other than driving, he doesn't know anything else. So for driving, we need the ears to be perfect. He is a deaf person and he is not able to. He is dependent on his sister, who is an auditor, and he is paying the fees. They are telling they are not paying the fees. Already they have filed an execution application, and we have paid all the interim maintenance which was pending, and also the educational expenses we are depositing in the court, my lord.
Yes.
My lord, your lordship may kindly see the
What is the-
exhibits
Every
where
time, after every one sentence, if you want to reply, it's difficult. Let her complete. If you want to tell me whatever you want to submit, you submit. Court will hear. Yes,
And what are the judgments they have produced, my lord? will
not the
come to
judgments. What is the age of the child now?
20, my lord.
Huh?
20. He's working also in somewhere in
he is a law student, my lord.
and also working in YouTube channel, anchoring his
What about maintenance to the child?
maintenance, educational expenses means we are providing him everything that I can get the statement from the whatever he has paid before the court, my lord, in the family court, in the execution court.
Please come. Then counsel for the respondent shall place before the court. What expenses? The father is bearing. with respect to, son, and what are all the amounts that he has paid so far.